Here's what we're going to talk about. I'm going to start off with some U.S. breach notification stuff. We'll talk about the possibilities, or actually now, as of about 3 weeks ago, the reality of a federal breach notification law. Some stuff that's going on overseas, how to handle this compliance stuff that's coming up around privacy, and what I predict might be coming in the future. I'm an analyst. I have to make predictions for the coming year, otherwise they take away my license. So I think for a lot of us, privacy law, it's a little confusing. There's a lot of it. It seems to contradict each other. I had a lot of spare time on Monday. Okay, so what I'm not going to talk about, I'm not going to talk about cyberbullying. I'm not going to talk about privacy in the workplace. But I am going to talk about breach notifications. And I promise you, there's not too many cats, because I only had I had a lot of free time, but not that much free time. Okay, I lied. Ooh, there we go. Okay, so there's been a lot of state legislation around breach notification. California started it all 7 years ago now. Adam, when did CA 1386 go into effect? What, 7 years ago? 8 years ago? 2003. Okay, 6 years ago. So since then, as of this past fall, beginning of this year, 44 of the 50 states have similar laws like California's. And the District of Columbia and Puerto Rico also have breach notification laws. And they vary a whole lot in terms of when you need to notify and who you need to notify. But in essence, they're all the same, which is if you lose people's private information, you need to notify them. There's a lot of stuff out there. Especially early on, companies like ChoicePoint were playing fast and loose with the rules. They would only notify customers in the states where they technically had to, under the letter of the law, as opposed to the spirit of the law. That's pretty much shifted, in part due to the fact that, well, 44 of the states have laws that make it happen now, but when companies like ChoicePoint got spanked really hard in the press and got a free trip to Washington, D.C. to testify in front of Congress about it, companies sort of wised up that people had some expectations about notification. About a year and a half ago, California tried to make PCI, which I'll talk more about later, actually binding in law, so that companies had to follow, legally had to follow these rules, even if Visa or MasterCard, whoever, wasn't making them. And Minnesota specifically did that back in August of 2007, where companies, financial institutions within Minnesota can actually go to the people who lost the credit card information and recover the costs to the financial institutions to replace credit cards, to cover any fraud that happened, things like that. And I suspect we'll see more of that as time goes on. But there's some new legislation, state level stuff coming in, or potentially coming up that'll be of interest to you. Particularly on the West Coast. In California, there's been a discussion of updating CA 1386 to make breach notices a lot more understandable. Right now, what needs to be in these breach notices is very vague. It just sort of says you need to notify people, and if it's going to cost you more than this much money, you can go to the newspaper, or you don't have to send a physical letter. You can put up billboards or run commercials. It's pretty vague what you need to do, and there's no real rules about what information you need to include in the breach notice other than the fact that a breach occurred. So the same representative who created CA 1386 has submitted AB 20, and it's currently being debated in the California legislature, which will mandate that notices be in clear, easy to understand English, because today a lot of these letters are not. They're very legalese sounding, and it's more don't blame us. We lost some information, maybe, kind of, sort of, and that's it. So you need to have name and contact information of the company, at the company who is notifying, so you know who to call if you have more questions. You have to say specifically what types of information were lost, whether it was a social security number, date of birth, medical record numbers, that sort of thing. You also need to tell them if you know what the date of the breach was, and or if not that, an estimated date or range of dates over which the information was accessible. And also whether or not that notification was delayed to the customer because of law enforcement involvement in the case. In a lot of cases, you get letters well outside a reasonable timeline because the FBI or the Secret Service or the local police are involved, and that's a perfectly reasonable thing to do, but people don't, that needs to be communicated so people have a better idea of how long this has been going on. You also need to have a general description of the breach, what happened, what you think is going on. you also need to include a list of what you've done to remediate the problem. And what how you discover. You don't have to say how you discovered it, but you need to say what steps you've taken to prevent that problem from happening in the future, and the estimated numbers of the breach and contact information for the major credit bureaus who might be involved with this, so that way you can contact them and get more information about this. And the whole goal of this entire legislation is to give people whose data has been lost an opportunity to do a better personal risk assessment of how much at risk they are, and so they can then take their own own appropriate measures like credit monitoring or a solution like LifeLock or Debix, or to change their accounts or to go to another provider, that sort of thing. And finally, if the breach exposes more than 500 California residents, the person who lost the data has to notify the state attorney general, so that way there's some central reporting. On the other end of the spectrum, this passed about a year ago. Massachusetts passed 201 CMR 1700, which I believe Ben, right? Ben will be talking about this more in detail this afternoon. But in essence, it lays down a fairly similar PCI-like framework for the state of Massachusetts for businesses to follow to protect people's data. And in particular, the things that I found interesting was that it had a sort of a European data directive where there has to be a designated security/privacy owner in each organization, sort of like FISMA does as well here in the US. But specifically, it called out doing a risk assessment, which I think this is the only state law that actually mandates a risk assessment, as opposed to just saying, you need to take security measures. This law specifically says, you need to go out and look at what things are going on and think about it specifically and make a decision basis on that. You need to analyze the data that you're collecting and determine, do you really need it or not, and only collect the data you need. Is there a question?
How much wiggle room is there for risk assessments? If I were theoretically the designated security owner and I said, there's risk up there, that's probably bad. Is that a risk assessment? How far do you need to go before you satisfy this?
Honestly, I have no idea. The line, it's literally one line that says you must perform a risk assessment. Ben, do you have any thoughts on that?
A lot of that stuff is going to be dealt with by the Office of Managers, so they can probably give you a better picture when they're actually drafting the laws. Do I get break for answer?
Yeah, why is Trevor being asked questions?
Well, you just asked one, so yes. You only get like 3/4 of a piece because you were snotty about it. And finally, around this is that you actually have to do a post-mortem on the event and investigate what you think happened, so you can make efforts to prevent that in the future.
I'm sure this will be covered this afternoon, but this law only applies if you have a combination of a first name and either a social security number, a driver's license number, or a financial account number of a Massachusetts resident that you're storing data. So this isn't for everybody necessarily. But
Correct. But it does apply to paper records as well as electronic records.
Is it true this law has been delayed in its implementation at least a couple of times?
It's been delayed at least once till twice now.
Once for May, and then now to June, was it January 1st, 2010, I think?
Yes.
Just to your point, most all of the laws, 24 laws, they are based around the original premise, which came out on SB 1386, on that very fact. So, for example, it says first initial or first name, last name, plus some other piece of information, and they have a long description of what that information could be. So, interestingly enough, and I'm sure that they'll talk more about PCI, let's say that someone steals your credit card number. Is that a breach notification under certain laws? So the question is, well, do they have your name? If they're reading track 1, then yes, they have their name and their piece of information. If all they're reading is track 2, and there have been cases and actual case law that shows this, technically it's not a disclosure of your personal identifying information, and they may not have to notify these places.
But PCI does specify each of those individual data elements.
But specifically to state breach notification laws, exactly.
You've been asking me for bread for months, so. Thank you. Okay, so this is just here for reference. There's a couple of good websites here on that track the state privacy laws in detail with some analysis. So when you download the slide deck later, there's the links for you. On the federal side, there's been a lot of legislation out there. This slide, I lied. There's actually there is now a federal disclosure law around healthcare records, which I'll get to in a little bit. Obviously, there's GLBA, there's HIPAA, then there's the other side of things, which is Patriot Act, FISA, CAILIA, which is all about surveillance. I said earlier I'm not really going to talk about it, but I just wanted to highlight that they're out there. We can talk in the hall later if you have some questions about those. It was too cute. I couldn't help myself. Okay, so has anyone else here heard of high-tech? This was a change to HIPAA that got put in place buried deep inside the economic stimulus package that passed last month. It's been floating around for a little while. It got tacked on along with a bunch of other things. And the interesting thing about it is that, so it took HIPAA, it gave it some more teeth. It mandates breach notification to customers if you lose their data. Specifically, if you lose more than 500 customers worth of data, an individual worth of data, you have to notify the Secretary of Health and Human Services. And the Secretary of Health and Human Services needs to post this information on their public website for anyone who wants to track this information. Strangely, though, and I'm guessing this was sort of part of the give and take of politics, if it was an accidental disclosure, whatever that means, then you don't need to notify anyone. You don't need to do a breach notification. If it was, oops, we accidentally posted all of our records online for 3 months. It actually needs to, you have to determine that it was a malicious actor who did that. Civil charges have gone up significantly for failure to comply with HIPAA, up to, in some cases, $1.5 million per year to an organization. If you have been found to deliberately ignore HIPAA or violate it in some way, you can now serve time in jail, which is a change from the past. Until high-tech came along, it was purely a civil penalties issue as opposed to a criminal one as well. But the other really big change here is that business associates, which in terms of HIPAA are the people who provide services to healthcare companies and health insurance companies and are handling your PII today and your PHI, in the past only had to have contractual terms with those health insurance companies and those medical care providers saying, we'll do privacy, we'll do security, and that would pretty much cover you right there if you had those terms in your contract. The Secretary of Health and Human Services has a year to provide guidance on what the new requirements are going to be, and it seems quite likely that they're going to be essentially the HIPAA requirements for healthcare companies today. They have to be much stronger, and they also fall under the same breach notification rules as the standard covered entities. And now for Mike's favorite topic, PCI. And it really is, it's really essentially SOX in a lot of ways. It's sort of like, oh, look, here's something if you want to do business, you're going to have to do it. I guess technically, there are people out there who do pure cash businesses. Most of them probably don't report it all to the IRS, though. I'm glad Mike laughed. Anyway, so essentially what you need to do is you have these requirements. Personally, I'm curious, aside from Mike and me, does anyone else here like PCI? Think it's a good idea? Okay, we have a couple people. Okay, I think PCI is quite possibly one of the best things to come along in terms of information security for most companies today. And the reason is that until PCI came along, most companies weren't doing any security. And yes, PCI has some issues. It's not as comprehensive in some ways as it could be. But the reality is that it lays down a great baseline for how an information security program could look for most companies. And most of those companies do not have a security person or did not have a security person and didn't really know what they needed to do and didn't have the incentive to do it. So, well, it's not perfect, and it really is a baseline. And so for the companies who are doing checkbox compliance, they're still not as secure as as ideally I would like to see them be, but they're still orders of magnitude better than they were a year and a half ago, where they had no security. So I think this is why PCI is a good thing. It really lays things out for companies and for people who don't know what they need, who don't know what they need to know and don't know what they don't know. Unsurprisingly, people other than us have security and privacy laws. In Canada, at the federal level, it really comes down to two different laws. There's the Privacy Act, which, much like the Privacy Act here in the US, applies strictly to federal government agencies and how they handle private data, what they can and can't do. And then there's PIPEDA, which applies to everyone but government agencies and says, things like, okay, you can only gather data for the intended purpose. So when you gather personal information from someone, you have to state, I'm gathering your personal information in order to bill you, or in order to provide you medical services, or whatever it happens to be, and you cannot reuse that data for other purposes without getting explicit written permission from every person whose data you want to use. And similarly, at the other end of the spectrum, you have to provide all the people whose data you have access to that data so they can verify it's accurate, and then you have to correct it if they tell you, that that data is incorrect. This bottom link here is David Fraser. He's a outstanding security/privacy blogger out of Canada. He covers a lot of issues specific to Canadian privacy law, but he also covers stuff here in the US as well as Asia Pac and Europe. Again, I had a lot of free time. Okay, so on the European side, the big thing, we've all heard about the European Data Directive. You can only collect data for its intended purpose. You have to allow people to correct that data, and there's a lot of requirements that follow through if you want to export that data out of Europe. Europe right now has gotten really schizophrenic in terms of privacy. You used to be able to say that Europe had much better privacy law than the US. They're much more privacy conscientious. But right now they're getting really weird. So there's no breach notification in Europe. So, and the penalties for losing data are non-existent. All the penalties are they're not reactive penalties. It's sort of like if you don't have this stuff, you can't do certain kinds of business outside of Europe and things like that. But then the EU recently said that they're going to allow BT to use its Form product. I don't know if people remember Form. They try to use it here in the US. It lets you insert ads dynamically into the data stream. It's a huge privacy invasion, and enough folks in the US said no that it essentially put the US branch of the company into bankruptcy, and BT pulled out the offering. It's not going to happen in the US. But it's going to be allowed in Europe, which is supposedly much more security and privacy conscious. Well, simultaneously, the YouTube arm of Google is getting in trouble because the EU government was embedding YouTube videos into their websites for citizens to look at, and they were violating laws around use of persistent cookies. So at one end of the spectrum you can't use cookies. Cookies are evil. At the other end of the spectrum but we'll push whatever ads we want down to you. That's okay. And then you go down to Italy, and you have the chief privacy officer for Google being sued because they didn't take a video down in an appropriate amount of time, so this guy could end up going to jail in Italy. So right now, they seem a little confused of what's okay, what's not okay. So we'll see what happens. And then at the same level, you have the UK data storage law, which is not actually a law. It's a recommendation that ISPs store information about customers' internet usage for a period of, I think it's 2 years. And it's not mandatory, it's completely voluntary, but if you don't volunteer to do it, the government can make you do it anyway. So it's really, like I said, I think schizophrenic really describes it best what's going on right now in terms of privacy in Europe. In Asia Pac, we have, in Japan, they recently passed a privacy law similar to the Canadian law that says, you have to limit data collection, you have to let people change it. In Japan, however, if you don't have, you need to have a designated privacy officer, and if the company is found to be in violation of the assorted rules around data collection, the data owner, the person who's responsible for that data in the company, can go to jail for up to 6 months. Not the company, not the CEO, the person who is specifically responsible for managing that data and make sure it's kept secure. So basically us can pay a fine of up to $300 and or 6 months in jail. I don't understand that part. You know, they don't seem quite in balance, but hey, whatever. I just won't do that in Japan. In Australia, they have a bunch of different, they have a slew of privacy laws. So it's out of scope. I could talk about that. We could talk about, you know, Australian privacy law all day and still have stuff to cover. So if you have questions, catch me afterwards. There's the Asia-Pacific Economic Cooperation. It's essentially like the EU, but a much looser framework. And really, the goal of it here was to sort of give the Asia-Pacific countries an opportunity to sort of loosely band together for negotiation purposes with the U.S. for economic stuff, and in terms of with Europe as well. And they have released, about 2 years ago, a privacy framework as well, similar to the EU data directive, except for one of these weird, too many cooks spoil the broth kind of things. The framework is really lightweight, and every single member country of it has stricter privacy laws than the framework itself. And yet, despite that fact that these privacy laws were all in place, no one could agree enough to have stricter laws than that, even though everyone agreed individually that stronger laws were a good idea. But what are we going to do about that? It's a cat. What can I say? So finally, the question is, you know, there's all these privacy laws, there's compliance requirements that, you know, privacy embedded in compliance requirements. How are you going to make this work? How are you going to, as the security person, and in a lot of cases, you're probably also the privacy person, how are you going to make this work? How are you going to realistically incorporate privacy into your security operation or into your corporation, especially these days when money is tight, and you have to sort of prioritize things appropriately. And it actually has to work. So really what you need to do to make this really work is understand the business. You need to know what data is being collected, who's collecting it, where it's going. At my previous employer, we figured, yeah, we're incredibly centralized. We have, you know, what is essentially one very large database that all of our customer data goes into. This will be a piece of cake. Yeah, how hard could it be to figure out, you know, where the data is coming from and where it's going? After all, it's all in this one giant DB2 database. We were so wrong. We figured this will be a 3-month project tops. We'll track it down, we'll draw some pretty pictures, we'll talk to our lawyers, we'll talk to our European lawyers, we'll publish policies, we'll be compliant with the European Data Directive in no time. It took us a year. And as it turns out that, well, just because you think it's easy, it really wasn't that easy. It turns out that there was customer data going not just to sales and into the production environment, but it was being mangled and put into test environments, and alliances had sharing agreements with some of our partner companies over, we'll share certain types of customer data with you, and oh, it turns out all of our conferences we put on were outsourced to another company, so they were collecting customer data that we had to track and make sure that was going on. So it turns out to be that it's an incredibly complex environment, but essentially what you need to do is get a team together, people together. It should be cross-departmental. You need people from legal, HR, sales, alliances, the whole 9 yards, any group that might conceivably touch customer data anywhere on the line. And you sit down and you draw a lot of really big, ugly pictures on whiteboards and convert those to Visio or something similar, and you track it down and you figure out where the data is going. Where's the money flowing? Because generally where the money is going is where the data is going as well. And then once you have that, you can start looking at what controls you currently have in place. Much like you would with a security policy, you make a list of controls for your data, and then you figure out what you need to change and what you don't need to change, and get the executive buyout. I mean, it's executive buy-off rather. Executive buyout's not bad either if you can manage that though. And essentially, you know, this is a long project at a larger company. We were a $2 billion company. You know, someone like a GE or an IBM, it's probably a 5 or 10 year project to really do this right. So I don't pity them, or rather, I do pity them a whole lot because it's not going to happen anytime soon. One thing you can do is there's a lot of companies out there. There's UnifiedCompliance.com. There's a number of other folks who have gone out and taken all these compliance requirements, Sarbanes-Oxley, PCI, all the other privacy laws, the ISO 27001 standards, things like that, and produce these really awesome spreadsheets that you can use so you can make sure that you have a comprehensive list of potential controls you need, but also so you're not duplicating effort. A lot of cases, you'll find that the existing controls you have in place for SOX or PCI overlap very nicely, and as you start adding privacy law on top of that, you need to actually change very little to make sure you stay in compliance in terms of what controls you have in place. And usually what's missing, in my experience, is logging and encryption, which in the general scheme of things aren't that bad. Okay, so here's the part where I put on my analyst hat and pretend to know what I'm talking about for the future. I think, the UK, there's been a lot of discussion in the UK, but in the EU in general, breach notification laws. New Zealand's going to start making some recommendations as well soon. They haven't yet. Australia, I can't tell. They keep going back and forth whether they're going to do something or not. We've been seeing a lot of pushback from vendors on the requirements for PCI. I think we'll keep seeing that. I think we'll see more on the data retention requirements. Because right now, a lot of folks have started to collect data they don't want to keep. So I think we'll see some flexibility coming out of the PCI folks just due to the pushback from the vendors. And I think now that high tech has passed and that there's a federal breach notification law for healthcare information, that it's really only a matter of time before we see a similar breach notification law for financial records, if not just an overall one for PII, regardless of what type of PII or the environment it was stored in. But that's probably further out than a financials-based one. And now just any final questions? People wanting bread? So just to make sure I'm rephrasing the question correctly, given the number of breach notifications have gone out, is there a desensitization to the customer about this? And as a result, are we running into sort of a potential chicken little problem that when something really bad happens, the customer won't care and won't know?
Yeah, and therefore should we be more, we as organizations that actually handle sensitive data, be more cautious?
I think that's a good question. Yes, should we as organizations be more cautious? It's a really fine line to walk, just because there's always the push coming from above that, what do we really need to notify? What do we really need to tell people, and when do we need to do it? I think what we need to do is get better at these breach notification letters so people really understand what's going on. I don't think it's so much a desensitization problem as, in and of itself, that if the data people are getting was more useful, sort of like the requirements of AB 20 in California, it wouldn't be that big a deal. It's like you look and go, oh great, they lost my home address and phone number again. Well, I'm in the phone book. Okay, whatever. Then you get another letter that says, we lost all your health records for the last 10 years. That's more of a big deal for a lot of people. So I think for me at least, I think the way it needs to go is people need more information about what's happening, and not just fewer letters.
Just to follow on, even if you know that, you just lost all my health records, or you just lost whatever. I mean, as a consumer, there's a very narrow range of actions I can take. I mean, essentially, in my view, the game's over. I just assume that all that stuff has already been lost. It's already out there, and so I guess I'm desensitized to use your terminology.
What's your social security number?
Go look it up. My name's on my badge.
The thing is that I think we're all desensitized to a certain extent, but for a lot of people, for a lot of people who are not in this industry, they're not desensitized. A lot of folks are very sensitive about this information being out there and are very frustrated by not knowing when they get a breach notification letter what that means for them. And you know, for me, I honestly, you know, if my credit card number gets stolen, it's a pain in the butt because I have to call Visa, I have to call my bank and get a new credit card, but it's not really a big issue for me because my potential loss is relatively low. If my, you know, my social security number gets out there, or more importantly for me at this point, if my son's social security number gets out there because it has not been tainted yet, I really want to know that so I can start taking corrective actions and start monitoring his credit or my credit. That's where you go into a huge problem. Once your social security number and your address and your mother's maiden name gets out there, you will start seeing, you know, houses being bought in your name. And at least these days, it's going to be a lot less expensive a house than it would have been 2 years ago. But it's still, I mean, that's where the real problem comes in for me.
Well, I don't mean to make light, I don't mean to suggest this is not important, but just something maybe you haven't looked at. If you go look at the genealogy database from the Church of Latter-day Saints, Mormons, I found both my parents, their date of death, and their social security numbers published online. So, I mean, it's a huge problem, but it's kind of like the horses are about 16 pastures down the barn.
Well, no, I agree. It's a huge problem, and the odds are, you know, that, you know, for all that data being available online, some of that is being abused. And I mean, it's the nature of things, and that's, you know, it's unfortunate, but it's true. But in the meantime, I want to know, you know, when my parents get breach notification letters, they call me up and say, you know, what really happened? You know, how bad is this really? You know, what are the odds of it being abused? Because the data is just not out there. The breach notification letters aren't sufficient today to make real decisions and get real data about what's happening. And the only way to figure out what's happening is to get more data. I'm a very data-driven person, and so I want to be able to say, look, you know, we have some very poor, you know, we have some potential great data out there if we could get it together, if we could share it amongst each other and get a real idea of how, how likely is it that if you lose 10,000 records versus 500 records, that each of those records is going to, that one of those might be abused or not abused. Right now, it seems like it that the larger the breach, the less likely it is that data is going to be abused, but it's really hard to tell because people aren't talking to each other. They're not sharing the data. They're not taking the information they have and saying, you know, we can mangle it so you're not identifying individuals, but let's get an idea of what's really happening. And the few folks who have some data are starting to talk a little bit about it, but they just don't have enough information yet to make really good claims. Okay, well, thank you very much. Oh, I'm sorry, I didn't see that. Yes?
Actually, I have two questions, not because I want a sandwich. With the PCIs, is there any evidence that they're going to change the privacy standpoint where the way that the credit card companies are doing business with merchants? And what I mean by that is that if I go into a local merchant and I buy something in cash, I get the cash, I get the merchant. If I go online, they not only have my name and my credit card information, rate and all that, but they have all the shipping information as well. Is there, I know there have been some rumors about change and some merchants being happy with it. Is there any movement on the way to change the way that the credit card business does business?
Okay, so the question was there any movement to change how the credit card companies are interacting with the merchants in terms of privacy, especially, I guess, particularly with online merchants? Okay. I'm not really deeply involved with the PCI Council. Like, I'm not involved with the PCI Council at all, so I don't have the foggiest notion. Mike, I know you're more deeply involved in this stuff. Do you have anything you can share with us?
I won't take up your talk. I'll phone it.
Okay. Well, I actually, can you give us like the 30-second overview? Because I think it was a good question.
Yeah, so we do lots of things with PCI, but when it comes down to what the card companies, really, it's not the card brands. The card brands are a little bit agnostic to the situation. But what they're looking at is specifically the banks, specifically trying to find ways to work with the merchants directly. When you're talking about the banks, you're talking about the acquiring banks that work with them, and a lot of the things they're moving towards are, and we're going to see this in the next 2 or 3 years, end-to-end encryption for the data breaches are from e-commerce situations. Europe, it goes up to 75, 85%. But in the United States, of those 50%, even then you're looking at it and you're saying that of those, I would say 90, 95 plus are from your top-put web apps. So a lot of companies here, they're dealing with application security in that respect. But a lot of the breaches we're seeing these days come from situations where it's a card-present point-of-sale environment, and the way to address those is from many different perspectives. So small-level merchants, they'll be able to address it with the end-to-end. Larger-level merchants, they may be able to do that, or they'll take other remediation strategies to get rid of the data. But ultimately, getting rid of the data is going to be the primary focus.
And the second question was, I remember when 13360 first came out, there was some loophole in the legislative side, right? And I think it seems the cases where they might have been encrypted as backup, so the archival was encrypted, and they were getting it out on that, but the processing system was compromised, so the data had actually gotten out. Have they closed those loopholes with any of the current regulations?
California hasn't done anything about that, and AB 20 doesn't address that either. Several states specifically have rules that say that the data itself had to be encrypted at the time of the loss. So it didn't matter that it was backed up on tape. If it wasn't encrypted when it was lost itself, even if the database is encrypted, but only when it rests, it didn't count. I know that Indiana, in part thanks to Chris, and some other states have specifically require also that encryption keys not be lost as well. So if it was encrypted, but you had the password written on the tape for the with the key, the password for the shared key or whatever on there, that did not count as being encrypted either. So a few states have addressed it to a certain extent, but overall, most states don't have any requirement like that.
When you mentioned unifiedcompliance.com, does that take into account all the other nations' laws as well, or strictly the set of U.S. regulations?
They do cover some of the European stuff. I know they've been expanding it over the last couple of years, so I don't know to the full extent that they do that. I do know they include the ISO stuff, though.
Are they pretty much the standard bearer, or if you need to comply with 15 different countries' laws, or is there a standard framework that's recommended?
Not yet. I mean, in terms of privacy, ISO is working on a privacy standard, which is what the idea is. European Data Directive covers a lot of the stuff that's necessary for dealing with privacy law between Europe and the rest of the world. But you start looking into the individual countries, and Italy's privacy law, I mean, if you printed it out, would be this tall in bound volumes, and the privacy laws between Germany and Portugal and Spain, the UK, are all very different when you get into local jurisdictions. So there's not yet a good overarching framework yet, but people are driving towards that in the long run.
Related, do you have any experience dealing with Middle Eastern countries' privacy laws? For a while, you sort of started working with countries that don't necessarily have developed privacy frameworks in cultures where laying down specifics about privacy or what you can and can't do with information technology is sort of frowned upon.
Yeah, I haven't really researched into the Middle East recently. I poked around about 2 years ago, and there was essentially nothing. It was sort of like, okay, no, there's nothing. So I'm not sure. I have not checked in the last probably 6 months, and I haven't really seen anything floating around there.
Are there any laws coming down aimed at making it more difficult to use this stuff and to steal it? I mean, most of the stuff you talked about was, what should you do to make it harder to steal? But, we all know that all it takes is a social number and birthday, and now you can open up a $10,000 line of credit in the right person's name. That maybe there need to be laws to tighten up that side.
There has been some. The question was, has there been legislative effort towards making it more difficult to use stolen data? Specifically, use it? No. Dianne Feinstein was working to get a law passed last year, which did not go through. Didn't make out a committee to significantly raise the penalties for identity theft. So it's to make the if you will deliberately use a social security number to pretend to be somebody else, then the fine, potential jail time and the fines were significant as well. So there definitely have been some efforts, and I suspect we'll see more of them this year. Leahy-Specter, which also didn't pass last year, attempted to put some financial penalties in place for identity theft as well. And pretty much all that stuff has been dying in committee one way or the other. As the problem gets worse, I suspect the incentive to make it more difficult will, in fact, finally kick in. Okay, one last question? So oddly, the original intent of the law was to encourage companies to notify by giving them loopholes out, like having the data encrypted and things like that. There is some incentive to not to report. A lot of the laws essentially allow people to file class action lawsuits against the company if they don't notify under the appropriate circumstances. So it's sort of, it's more of it's a built-in financial incentive for people to report. Certainly under high tech, if you don't report, the penalties are significant. And I think that seems to be the going trend, is to make it, to make the financial penalties higher and higher to encourage companies to report. Certainly when CA 1386 first came out, I spoke to all my peers and said, assume you have a breach. What are the if you have a breach, what are the odds that's going to leak out? So you have to do sort of do a real risk assessment, because your CEO and your chief corporate counsel are going to say to you, how bad is this? What's going to happen if we don't notify? And potentially the answer was nothing, or a class action lawsuit, which of course could run to hundreds of millions of dollars in theory. Who knows? High tech, certainly, if you maliciously cover something up, I suspect that they will take that to the criminal charges level, and which jail time is not fun, I'm told. Okay, thank you very much.
Everybody's been to cons before, the spiel about filling out the eval forms. Please fill out the evaluation forms so that we can get more bread next year.
It was a little underdone in the middle. I pulled it out the oven a little too soon, so it was.
That's always the question, is timing.
Yeah, and I was sort of in a rush, and so you can see, it's actually still actively doughy.
Oh yeah.
But yeah, but I should have taken its temperature.
Oh, you do that? Usually?
Yeah. If it's over 195 Fahrenheit, it's done. Did you get some?
No, not yet.
Here, grab that. It's actually done there. Yeah, thanks.
So hard to get good bread.
This part's mostly done. There you go.
Thanks. What did you want? My wife made me bake just before we left. She wanted cinnamon bread. How many of those can you eat?
A lot, it turns out.
2 or 3?
Yeah. But she's pregnant.
2 pounds of bread before. I was in a rush, I was packing, so all the kneading, like dump it in the bread machine and bake it off in the oven. Okay.
I'll be back in a few minutes.
Okay.
that. I know about